name is Josh Gilliland, attorney blogger for Bowtie Law and the Legal Geeks. Today, we are here to talk about eDiscovery in the cloud. This video podcast is sponsored by Nextpoint, and Jason Krause from Nextpoint is here with me to talk about eDiscovery in the cloud, cost savings and ways to handle data and being able to review in a cost-effective manner. So Jason, how are you doing today?
Great. Obviously, you picked a topic close to my heart, and because we at Nextpoint, obviously, we have a cloud eDiscovery platform, but I'm not going to be talking about us today. I just want to talk about why it is that cloud computing makes sense for eDiscovery. Obviously, cloud computing is taking over software in most industries, but there's legitimate concerns about eDiscovery in the cloud, and we're going to talk today through those ethical and practical concerns. And then at the end, I think we're going to probably talk a bit about exactly how it is that the cloud is more cost-effective for eDiscovery. The fact is, eDiscovery is ideally suited to maximize the benefits of the cloud. Problem is that in litigation, the exploding volume of electronic data is just crushing most matters. As a matter arises, a law firm or corporate counsel, is suddenly faced with a mountain or tsunami or whatever analogy you want to use of electronic data, which can cost hundreds of thousands of dollars just to process in-house or even with the help of outside consultants. And then there's the licensing fees, the software installation, the hardware costs, the consulting fees, all of which can make the costs quickly spiral out of control. And that's why a few years ago the eDiscovery Journal did a survey, and they found that roughly 75% of law firm respondents were leaning towards a cloud or SaaS, software as a service, it's another acronym for cloud, solution for eDiscovery. I wanted to throw out a quick case that I've written about on our blog in the past, which is Vinter v. Gallo, and I know you may have some other scare stories or case examples you'd like to throw up, but this was a case that involved 62 gigabytes of data that had to be processed and reviewed. The matter was dismissed in 2 months, but the bill for eDiscovery services still came to $111,047.75, most of which was for Bates numbering, document conversion charges, things that are typically involved or included in a cloud service.
Jason, if I may, I'll throw out two other examples. In one case where they had 68 gigabytes to contend with, the processing cost in that one was just a mere $18,000, but the estimated linear review of it with contract attorneys working at $49 an hour was close to $760,000 for that estimated cost. But that was probably doing it the hard way of literally the death march through all the data.
Wow.
Another case where they had 166 gigs, their estimated processing cost was at $91,000. A lot of money.
Yeah.
And I mean, that's still a huge volume of data. So there wasn't a discussion if any early case assessment had been done on it, if these were targeted collections or just mirror images of data. Because when you try to get down to the actual usable data, it's probably much, much less in the final analysis. But when you throw in the brute reality that people have 64 gig smartphones, which would be, I believe, 2 or 3 times the size of all the collected works of Beethoven digitized, I think 3 times, maybe just 2. I would fill all the 2 floors of a scientific library. That's a lot of stuff.
Yeah.
I mean, it's probably just random text and messages and pictures is what you're dealing with, but it's still a lot of stuff.
Yeah. It's easy to see why these things get out of control really fast. And unfortunately, those are just a couple reported cases, which is it's fairly rare that you actually get to see these things laid out in a court decision. So it's probably it's interesting to see how all over the map just these 3 cases that we happen to come across are. The important thing to know about a cloud service is that basically you're paying a flat rate to store and access your data, and the application, IT, networking costs, all of that stuff is basically included in what you're paying for, this flat rate, as opposed to paying a flat rate for storage, which can start at 40 gigs $40 a gig and up, and then you're paying for the licensing fees and processing and stamping and all that other stuff. Just you can see how it quickly adds up and gets out of control. But before we get too far in the weeds, maybe we should just take a quick look at exactly what we're talking about. And so this, unfortunately, I have on the wrong slide. But this is a definition of cloud computing that I took from Fast Company, which defined cloud computing as a network of low-cost, high-availability computing resources, which is still probably a little too wonky. But basically what we're talking about is, for example, Nextpoint, we use Amazon Web Services to host our services. And that's basically a multi-billion-dollar company that has invested in data centers, huge data centers all around the country, full of thousands of computers that you basically rent to use the services that you need. So as it says below, you're only paying for the resources that you consume. And then obviously you're also betting on the billions of dollars of investment that a company like Amazon or Microsoft has made in protecting their data centers against hackers and network outages and that kind of stuff. So the idea is that you're paying for a service that's infinitely more secure than anything you can build yourself, and then you don't need to purchase the hardware and build things out yourself. And also, you're basically able to bring on all the computing power that you need as you need it. And then this is a slide that I actually stole from a guy named Kevin Remdy. He's an evangelist over at Microsoft. It's a great job title. I got to figure out how to get that myself. But he sort of outlined the what you're buying or what you're paying for, what you're responsible for in the different software service models. So on the far left, you've got the basic model that most people are probably familiar with, which is you buy the applications and you host the data yourself. And then I don't even know what all the other stuff is below that, but that's what your IT staff that you have to pay and maintain is responsible for doing, which obviously is not in most law firms' wheelhouse. And then there's different software models sort of going all the way across to the right-hand side, which is a true cloud or software as a service, SaaS model, in which you're basically paying someone to do all that for you, and usually at a much lower cost than you could ever do it yourself. And so that's a quick overview of what cloud computing is. And now I'm going to throw it to Josh, who's going to take us through the ethical and practical concerns about using cloud services for eDiscovery.
Every lawyer in the United States has a duty of competency to their clients. The ABA model rules define this, and each state has either adopted the ABA model rules or put their own spin on it or written something completely different that still does the same thing. You have to be competent to practice law. The ABA rules with their 2020 project have added a requirement to know about technology and representation. Now, this does not mean every lawyer has to go out and become a computer certified expert, but you got to know who to talk to, and you also have to know enough to know what to ask for help with. Cases in point. The lawyer who represents someone who had a traumatic brain injury is most likely not a brain surgeon in their spare time, but they know what experts to talk to for help. The lawyers who do construction defect litigation do not personally rip out windows as part of destructive testing. They hire experts to do that who write affidavits, and then they know what to argue in court based upon the facts because they do understand the law and they're able to apply the facts to the law. eDiscovery and technology is no different. You have to understand the basics of it, much as we understand the basics of driving our cars. Not everyone goes out and changes their own oil, but they know to go to a service station and have the oil changed. I don't remember the last time I actually changed the oil in my car, probably over a decade, but I still get it done every 3 months because that's what you're supposed to do. Understanding the technology in eDiscovery I think, will be similar to that, that we'll become used to it. And while many people cannot describe how an internal combustion engine works, they know how to turn the key and drive someplace. And that's how we have to look at technology when it comes to eDiscovery. It has to work, and we want to make sure it works. Back to you, Jason. So we also have the California rules. Now, there are many states that break down eDiscovery ethical obligations, technology obligations, virtual law office obligations. And this California State Bar opinion that came out, this was from the end of 2010, dealt with a lawyer who went to a coffee shop and sent emails or did doc review on the coffee shop's Wi-Fi, and something went horribly wrong. So wrong that somebody ended up writing to the State Bar and going like, hey, was this ethical? Did this lawyer violate their duty of competency and client confidentiality by using this public Wi-Fi system? Well, that opinion resulted in the 6-point test lawyers have to do, not just if they're accessing Wi-Fi, but anything that's storing client confidences. Well, that's cloud computing, plain, clean, and simple. So when you think about the 6-point test, what level of security does the technology have? The legal ramifications to a third party who intercepts or accesses that information, the degree of sensitivity of the information, the possible impact on the client of an inadvertent disclosure of privileged communications, the urgency of the situation, and the client's instructions. So when you break it down and really think about it, this means lawyers who work from home on their home Wi-Fi with the law firm computer need to do a 6-point test, which basically boils down to, was your wireless router password protected? Did you have a firewall on your computer? Were you just using terminal services? What's the story here to make sure that you are acting in a competent manner to preserve client confidentiality? And the same would hold true for any hosted repository. So, Jason?
That's great. So obviously those are the high-level obligations and concerns that you as a lawyer have to think about when looking at your technology purchases or the services that you're using. And so from a practical standpoint, what that means when you're looking at a cloud service is looking at making sure that they are taking full advantages of the security and the scalability and the technical abilities of the cloud platform. And from a practical standpoint, I threw out a few things here that means, which obviously they need to have a firewall in place. You need to inquire as to what level of encryption they're employing, both when your data is being stored at rest or in transit between parties, the intrusion detection that they're using to protect your data. And then there's some important questions about geographic redundancy, which is about where your data is actually stored in the United States or around the world. So we recommend that attorneys notify new clients that their electronic data may be stored with a third party during the course of representation. And that could appear in your engagement letter or any agreement you have with a client. And then these agreements should also specify that data will not cross international borders where it can be subject to data privacy regulations. Nextpoint, as I mentioned, uses Amazon Web Services as our host provider, which gives us the ability to ensure that data is stored within the continental U.S. or even within a specific geographic region in the United States. And so when you're looking at a cloud service, there's some obvious and important questions that you should always ask a provider. Make sure that your cloud provider is taking full advantage of the cloud platform in all phases of data transmission and storage. And that means you want to look at their service level agreement, how available is the data, what are their guaranteed uptimes, what are their charges for the eDiscovery services itself, the processing, the bait stamping, all that kind of stuff. And then, as I mentioned, you want to ask about the data controls, what level of access different users are going to have to data, who's allowed to access the data, the geographic controls, and then an important question a lot of people forget to ask is, do you actually get your data back at the end of a matter? It's an important thing to make sure make sure that you're guaranteed. And those are sort of the important high-level questions. And there's obviously some more detailed questions. You should probably bring an IT guy who knows some of those questions specific to your practice area. But Josh, I guess I'll open it up to you. And any more questions as a lawyer about why cloud platforms make sense in eDiscovery?
Well, let's break out Craig Ball's Aetna challenge and focus on the needs of small clients. I've challenged many software companies to go to the local state courthouse and watch the case management calendar for an hour. The case managers in my hometown will deal with 100 cases over the span of an hour, 2 hours probably. Very busy calendar. And all those cases are in the $50,000 range to $250,000 range. These are regular people, small business owners, you name the type of case, from family law to breach of contract. And they do not have massive budgets to afford not just the $1,000 to $3,000 a month for the attorney's fees that they might be doing, or if there's motion practice, that could balloon up to 10 grand because of all the time the lawyer's going to spend working on a motion, to have like a $3,000 bill on top of that to host data for document review. So how would you strategize to help people whose literally their discovery budget's probably $5 grand at most?
Yeah. Well, as I mentioned earlier, with a cloud model like ours, we charge basically that flat $25 a gigabyte charge just to upload your data, and then you have access to our applications and services on top of that. And so obviously we keep prices low by charging what I think are the lowest prices per gig in the industry, but on top of that, you have the ability to control the level of work that's done after that. So our model, a cloud model, is also can be a DIY model, which means you upload that data and then you have access to that application. And depending on your level of competency and experience in reviewing electronic data, you can do more of that work yourself. And we've always tried to make the application, our service, as accessible to as many people as possible in order to give people the power to control those costs, so things don't get out of control, as we talked about in some of those few reported cases earlier. I'm not just saying this. Like, it's an important thing to us that we make these services available to all parties, whether it's a small family law case up to the huge, multi-district, multi-terabyte corporate cases, because it's important that more people have access to justice. And I don't think I'm getting carried away to say that, unfortunately, your technology costs are a big part of that today. And so we firmly believe that cloud computing platform is a big part of making discovery affordable again in more types of cases.
I would also add that a lot of the forensic companies have been leaders in helping control costs, because I can name 4 or 5 companies that have come out with inexpensive products, literally under $500. One of them's $100 that can do the target collection or the drag and drop, or the collection expert writes a script for, puts in an hour worth of time to write the script, and the product's $250. So you're looking at maybe $500 total to extract the data in a defensible manner and then upload it to a service such as Jason's at Nextpoint. And you can have a very affordable discovery model that way. And I would credit all the forensic companies that have come up with the great tools that can help everybody.
Yeah.
I mean, like, they really should get a medal for all the help that they're giving people. And and you don't see a lot of marketing on that stuff because marketing generally focuses on the big cases. But a lot of these companies have developed stuff to help common litigants, the regular guy, and that's truly, really good for them.
Yeah, I mean, it is unfortunate that a lot of the attention in this industry has focused on those huge multi-million-dollar cases because obviously that's where the money is. But you're absolutely right that it's important that people have the power to control those costs early going in because, as you mentioned, you can you can discover I don't know how many megabytes of data from a typical smartphone nowadays, and if you're not careful, if you don't control and sort of we minimize the amount of data that you're collecting early in a matter, you can wind up with just an unsustainable amount of discovery to pursue for a small case, and it's just not going to be worth it financially.
Now, and a lot of lawyers don't recognize there are ways to do this in a cost-responsible manner to help their clients, and it comes from the cloud service providers like you, and also from all the great forensic collection companies that have figured out ways to help normal litigants with their litigation.
Yeah, and also for lawyers to take advantage of all the resources available to learn how to do a lot of this stuff themselves without getting charged an arm and a leg by some of our competitors out there.
Yeah, there are a variety of different solutions, and so talk to the service providers that you use. The collection guys are generally pretty good at this and want to help solve the problem because, again, if I know collection guys that people will come to them with a divorce case, and they actually do want to help. They'll figure out a strategy to help that person and have it be, $500 to get the information off a laptop. They'll come up with the ways to be helpful so people have access to justice, because that's generally why we're in this business.
Yeah, you bet. I mean, that's an important point because especially in a lot of those family law cases, unfortunately, there's a lot of emotion involved and people get angry and they want to find that proof. They want that smoking gun email, and they're just going to spend and spend until they think they find it. And a lot of times, smart examiners are going to have to tell their clients like, whoa, let's hold on, let's be smart about this. Let's just settle this matter as effectively and as inexpensively as possible.
Exactly. And so while there are the many good service providers out there that will help people, there are some who have gotten into trouble. And so it's important for an attorney who's looking to engage a service provider to talk to them about the duty of confidentiality and to make sure that the service agreement binds the service provider to the attorney's duty of competency and duty of confidentiality and all those things that a lawyer is ethically responsible for, to make sure that the service provider doesn't cause problems by not having password protection or whatever. Name your nightmare scenario. The classic of, what do you mean the data's in Minsk? People don't want that to happen. And so find out, I'm a California attorney. All the data has to be subject to the California Data Privacy Act. Service providers in Nevada, make sure the Nevada service provider is going to follow California law. And it's basically a checklist. And asking them, how do you comply with this? And they should be able to, because all these service providers do build good security to protect everything. There have been nightmare scenarios, and it's happened more than once, where a service provider, for whatever reason, doesn't get paid by a law firm. And some creative attorneys get the idea that they could auction off the work product from the litigating attorneys who have not paid their bill for whatever reason, whatever dispute's taken place. And that is a horrible plan if you're an attorney representing a service provider, because you will literally burn every bridge that service providers had, and they will never work again if they take the point of view that we can sell work product to the highest bidder. Not a good idea.
No, I love those stories. And just to be clear, at least from Nextpoint's point of view, we have no interest in owning your data. Like our service level agreement makes it clear that you always own your data. You're free to it whenever you're done using the service. So we have no interest in holding anything hostage, that's for sure.
Yeah, I was not implying that was you guys at all. So
but I hate to say it, but these are some of the questions you've got to ask your providers. Make sure you ask them the hard questions. Make sure you can get your data back at the end of a matter. That's an important question. And as you mentioned, anyone who runs into a problem like this, they're probably not going to work again because it is a small industry and everybody knows everybody. So ask around and get references because you'll learn some things pretty quick.
Yeah, and a lot of these service providers are willing to do a proof of concept. They might be willing to, do a sample case, put in a small amount of data and let the lawyers play with it. So there are ways that you can find out, is this the right service provider for you? From search efficiency reports to all kinds of engagements to basically do a test run. And a lot of these folks are willing to do that or give references. And because lawyers are trust-based creatures, and talking to another lawyer that's used a service provider who will say, I loved my case manager, we did all this good stuff, really helped me out, lawyers generally respond very well to that.
Yeah, you bet.
So with that, I want to thank everyone for tuning in. Again, this podcast was sponsored by Nextpoint, and I want to thank Jason for sharing his thoughts and expertise. He has a lot of experience in this area, and always a pleasure. And for more, check out nextpoint.com or drop either of us an email, and we'd be happy to chat.